Thank you all once again for joining us today. For those who are joining us for the first time, I'll introduce myself. For those who've been with us all day, this is the fifth time you'll hear this introduction. I'm the moderator for today's program. My name is Bryden DeWitt, and I am a partner in our employee benefits section here at Williams Mullen. I've focused my practice on all areas of employee benefits law, including qualified retirement plans, such as 401k plans, health and welfare benefits, ERISA fiduciary duties, and benefits issues arising in mergers and acquisitions. Now I'd like to welcome Amy Pruitt and Kevin Pomfret. Amy Pruitt is a partner with our IP section and based in our Charlottesville office. She counsels companies and individuals in global industries on protecting, maintaining, and enforcing their rights in brands, names, marks, copyrights, and other intellectual property assets. Amy helps parties navigate through complex and challenging conflicts to identify interest-based solutions through mediation, collaborative negotiation, and alternative dispute resolution. Kevin Pomfret is a partner in our corporate section based out of our Tyson's office. He represents a wide range of public and privately held companies in a variety of corporate matters. His experience includes entity selection and formation, raising funds from angel investors and venture capitalists, mergers and acquisitions, and private equity transactions. In addition, he counsels companies on technology joint ventures and software and data licenses. Amy, take it away.
Thank you, Bryden. So happy to be here today. And just to start off with our first poll, it's an easy one. I wanted to get a sense of where everyone is coming from and would like to know what primary role you play in your business. So there's 5 choices here. You can, maybe you're in the general counsel or legal department, maybe human resources, finance or accounting, intellectual property or technology. Maybe none of those apply or something other. There are 30 seconds left. And remember, as Bryden said, we do need to have all questions or polls answered to get CLE credit for this session. All right, 10 seconds left. And as expected, so since we have CLE credit today, it looks like a lot of you are coming from general counsel or legal departments, a few of you from HR, some IP, that's great, and some others. So so great to have you here. We'll talk a little bit about intellectual property just to get started, as some of the cases that we'll be talking about have some IP concerns. So next slide, please. IP comprises several different areas, and you might have heard about patents, which cover inventions, processes, know-how, any type of idea that is novel and is something that could be useful is protected by patent. Copyrights protect works of authorship, and that includes things like books, movies, music, computer software, as well as architecture blueprints, many different types of works, as long as they have some type of expression of an idea. Trademarks cover brands, marks, symbols, logos, names, anything that might be used as an insignia to provide products or services. Trade secrets is usually a secret that is kept confidential in order to benefit economically within a business by virtue of its being kept a secret. Next slide, please. So we'll focus on copyrights, as a lot of the cases when it comes to generative AI have to do with use of copyrighted materials in training AI, and copyright protects original works of authorship, which are fixed in a tangible medium of expression. So what that means is that it has to be set down in some type of tangible format, like a recording or a printed piece of paper or some type of format that is can be seen or viewed or heard. And it also is a work of authorship, so it has original authorship. And we'll talk about what that means in some of the AI cases. And they can include any type of literary, dramatic, musical, artistic work, such as poetry, novels, movies, songs, computer, software, and even architecture. Next slide, please. So why do we protect copyright? Well, Congress decided to put in copyright laws to incentivize human creativity, and believe that protection of the copyrights is a way to incentivize that creativity by recognizing the ownership of copywritten works and providing fair and economic rewards. There's also penalties for copying works that are protected by copyright, and any type of piracy. So you may have heard of music cases where companies are taking and streaming music without permission, or having some type of piracy and using those works on their either websites or in their business, and there are penalties for that unauthorized copying. And another benefit is the enjoyment of culture. So the Copyright Office collects all the works that have been created by society over the years, and to promote the knowledge and entertainment in our culture. Next slide, please. Copyright is different from other IP. So those other three areas that I mentioned at the beginning include different areas of IP. Copyright is different in that it is works of authorship, while patent, for example, protects the inventions or ideas. So copyright does not protect the idea alone, or even just a theme, but it protects the expression of the idea, whether that's written down or recorded, or some type of musical expression. And the ideas and discoveries may be protected by patent if they are novel and follow some other guidelines to protect patent. And then it's different from trademark in that words and phrases, short symbols, short slogans, for example, are not protected by copyright, but rather by trademark if they're used in a business to provide services or products. Next slide, please. The exclusive copyrights include the right to make copies. So if you have a copywritten work, you can prevent others from making copies of that work. It also includes making derivative works. That means making a work that's substantially similar to the original, maybe a few changes, but it is derived from the original work. The right to distribute copies to the public, the right to perform the work publicly if it's a dramatic or a musical work, the right to display the work publicly if it's an artistic work, and the right to perform musical work by digital transmission. So this was added in the advent of the internet, when music was available over digital downloading, as well as other types of transmission. So it was specifically added to the copyright rights under the Copyright Act. Next slide, please. Fair use is another topic that we'll talk about when we get to the AI training cases. And some of the AI platforms are relying on fair use as a defense to copyright infringement. And there's a number of factors that a court would look at to determine whether use of a copyrighted material constitutes fair use, in which case they would not be liable for copyright infringement. So if a use of a work is for purposes of criticism, comment, news reporting, teaching, scholarship, or research, then it is entitled to this defense. So that might be news reporting on some type of copyrighted content, and that the benefit to the public outweighs the ownership of the copyrighted work and all of those exclusive rights, such that there is a fair use of the copyrighted material. The factors that a court would consider include the purpose and character of the use, whether or not it's commercial. So the more commercial a use of a copyrighted work, the less likely it's going to be considered a fair use. The nature of the copyrighted work includes whether or not it's educational or informational. So some factual types of works may not be as entitled to copyright protection, first of all. And then second of all, if somebody is using that work if it contains educational and factual information, then it may be a fair use. A court would also consider the amount and substantiality of the portion that's used. So if a substantial amount of a work is used, there might be less of likelihood that it would be entitled to fair use. But if there's very minimal used, there may be a fair use. There's also this idea of whether or not it's the heart of the work that's being used. So if, for example, you're using the hook of a music song, which is the key verse that most people recognize when they hear a piece of music, but maybe not the rest of the song, even though it's a short bit of music, it might be enough that it's still considered copyright infringement and not a fair use. And then lastly, a court would look at the effect on the market for use of the work. So is it a different kind of use that the original owner may not have done? And an example here is with parody. So if somebody takes a work and changes it so they are making fun of it or doing some other type of a parody piece, then there might be enough to consider it a fair use. Next slide, please. So getting into artificial intelligence, and for this, we'll do our next poll. And again, remember, answer all questions to get CLE credit for this session. This question is, how often do you use generative AI? And the answers or the options are all the time, once in a while, not at all. What is generative AI? Maybe that's why you're here. So I'll give you a little bit of time. Thirty seconds left. Final 10 seconds. Get your answers in. And we have about 8% of you that use it all the time. That's great. Once in a while, it seems like most people fit in this category. It's about 47%. Not at all, which is 42%. And a few of you didn't quite know what generative AI is. So that'll get us to the next slide. We'll start with an explanation of what that is. AI refers to computer systems that are designed to perform tasks that typically require human intelligence, such as visual perception, speech recognition, decision-making, and language processing. Generative AI is a subset that focuses on generating new content like text, images, audio, rather than just processing existing data. So AI itself has been around for a long time, but generative AI has come into more popularity with a lot of the tools that newer platforms are providing. Some key examples include these large language models developed like ChatGPT, OpenAI's ChatGPT, Anthropic's Claude AI, Google's Gemini, and Huawei's Pangu Alpha. Apologize for any mispronunciation. And these are trained on vast data sets to generate a human-like writing. So if you put in certain prompts, it'll provide some type of human-like writing in response to those prompts. There's also some image generators like DALL-E and Stable Diffusion that can create original images by just describing them in text. So once you put in those text prompts, they can create these original images. There are also speech and audio generators that produce realistic sounding speech or music. Next slide, please. So an example of using Claude AI, I just decided to put in when I was asked to do the CLE presentation. Will you please draft me a CLE presentation based on recent cases filed by musicians, artists, and writers against AI programs training their LLM with copyrighted material. So LLM is large language models. So the answer I got when putting this prompt into chat or Claude AI was that they'd be happy to draft a presentation for me. Great. And they suggested some titles for me, as well as an introduction and an outline here of what I would talk about in that presentation. I asked it further questions after that, and so they would flesh out each of those. You could ask it to give you a little bit more detail on each of those sets or part in the outline, and they would respond with something that you could talk about. So it can be a very useful tool. Next slide, please. So a key case, and we'll talk about several different issues that have come up with the training of large language models, as well as the use of generative AI to create a work. So the first case that came up was on the question of ownership of a copywritten work that is created by AI. So in this case, Thaler versus Perlmutter, which is a copyright office, there was an owner, Thaler, who he created actually an AI system that would use all of the different artistic works to create another one. And so he used his own AI system to create a new artistic work, and this is what was generated by his program. And he submitted it for protection with the Copyright Office. It was denied. The Copyright Office said, no, a human has to own the copyright. It can't be generated by AI. So he's filed an appeal and tried to claim that as the owner of the AI system, he also owns the right to the copyright. And that is currently being decided. You could go to the next slide, please. So August 23, the district court affirmed that the Copyright Office's refusal to register the work necessary, that a human has been the one to create that copyright. And it's based on the text of the Copyright Act and longstanding legal principles. This is still on appeal with the DC Circuit. And as I said, some of the arguments that have been made were that the artwork was generated by his own computer program, which he called the creativity machine. Another issue that has come up is whether or not it's a work made for hire. If a company has an AI system and they hire essentially developers or creators to create the prompts to create a work, could that be a work made for hire, which is also protected by copyright laws? Just recently, another artist has filed a lawsuit against the Copyright Office because his work was denied protection based on the fact that it wasn't created by a human. So the artist there, Alan, said that he had selected colors and style of a Victorian era. So these were some of the prompts that he put into the AI system. And the women were dressed in elegant dresses, wearing space helmets and performing opera. So he thought that that was a unique juxtaposition between old world charm and a futuristic twist. And he's trying to argue that in his complaint against the Copyright Office, that it should be entitled to protection. So as I imagine, some issues will come up that concern whether or not those prompts are enough of a selection and contribution to the copywritten work to constitute human ownership, or does the AI fill in all of the copyright, what would normally be protected by copyright, such that it's no longer a human that has created it, in which case the Copyright Office would likely deny it. Next slide, please. So as a little background to why, or some of the cases that have led to the requirement that a human own the copyright, is a unique case involving a monkey or macaque that took his own photos that were set up by a photographer. And there were several cases on this issue. PETA was trying to argue that the monkey himself owned the copyright, and the photographer was trying to argue that he owned the copyright to get the photos taken down on some sites. And the argument by the photographer was that, well, he had this camera on a tripod with large wide angle lens, and he'd used settings to optimize the chances of getting a close-up, as well as a remote shutter trigger that was right next to the camera, making it easy for the monkey to take his own picture. And all of these settings were important creative judgment such that they should be entitled to copyright. And unfortunately, we never got a real decision on that other than a court saying that a human did have to own the copyright, and the parties did settle before a decision was made there. Next slide, please. So the Copyright Office, in response to some of these ownership issues, has put out some copyright statements over the last couple of years, asking whether or not it's a mechanical reproduction of an author's own original conception in order to entitle it to copyright protection. Can the AI be technically a co-author if you have an author going in, putting enough prompts so that it's an original intellectual conception of this author, but also in contribution with the AI? Is there enough human contribution to entitle it to protection? Is a prompt enough? Probably would need to at least be a selection of prompts. And who has the ultimate creative control? Is the author there changing things and making it unique, such that there's enough to have a number of copyrightable elements? So there's been public consultation on this, about 10,000 comments on the reports, and we don't have the report yet on this particular issue, although the Copyright Office has issued a comprehensive report on the digital works regarding uses of fakes, which we'll talk about in a minute. Next slide, please. So a little hypothetical, and you can throw it in the chat just based on what we've talked about so far. And this is not required in order to get CLE credit, but thought it would be fun. So let's say there was a song that I wrote with AI prompts that said, please write in the style of Beethoven in 2/4 time. So that's 2 beats a minute measure, with a Chopin-like melody. And then I would edit much of the melody. I would change some of the notes, maybe up or down, keep the rhythm, key, time signature, and some of the other elements that the AI had created. And if the application is denied by the Copyright Office, you can throw in the chat what you think it should be, whether protected or not protected. Okay, we'll go to the next slide, please. I don't see answers in the chat, but perhaps they're in the questions and answers later. Okay, so I see not protected, I see protected. Yeah, so you can throw your answer in the Q&A since the chat is disabled. Not protected, not protected, protected. So kind of a mix. I see some arguments for and some against. And I think that that would be right. There would be some arguments that because the author has contributed with the selection and arrangement of the music, that there could be maybe some co-authorship. So with training AI, there's been a number of cases in the 10s, 20s now filed against some of the AI programs based on using copyrighted works like music and art to train the large language models. So they're creating copies. The arguments are that they're creating copies and displaying these copies, maybe doing some mashups of them to train the AI so that ultimately when they release the AI program to, or if a consumer uses the program, that there's some potential that the copyrighted work would come up as a result. So the issues that come up are whether or not they constitute direct copyright infringement and or contributory infringement, and whether there's fair use there. Next slide, please. So the writers' cases were some of the first that were filed last year. And David Baldacci, Sarah Silverman, who's a famous comedian, and many others filed against the some of the platforms, saying that they'd copied their works completely without permission or consideration, using them to train their large language models, and that they were designed to output human-seeming text responses. So it looked like if a consumer went in and put their prompts, that they would get the plaintiff's copyrighted works as a result, and believe that this was systematic theft on a massive scale. And currently those cases are in discovery right now, as there were a number of back and forth, some motions to dismiss, and some of the contributory infringement claims were dismissed, but not the direct copyright infringement claim. Next slide, please. And some of the news cases have also been filed. Last year, New York Times sued some of the open AI platforms for using millions of their copyrighted news articles to train the AI system. And recently, this past September, OpenAI asked the judge to dismiss some of these claims, arguing that they should be pared down to the core issue of how the fair use doctrine applies to training AI with copyrighted materials. On the contributory infringement claims, OpenAI has said, well, they can't be liable for third-party copyright infringement. So essentially, it's the consumers that are going in and potentially getting a copyright infringed work from those prompts, because it's only generally knowledgeable that such infringement exists, and that much more has to be shown for contributory infringement. Next slide, please. And the music and art cases have been also very prominent as well, with the some visual artists filing last year for using billions of copyrighted images to train their AI, as well as music publishers suing Anthropic for training AI with music lyrics, as well as the Recording Industry of America alleging that they'd stolen copyrighted recordings to develop technologies and create synthetic musical outputs that infringed their AI. So many of these cases have been continuing on and kind of in the pleading stage. With the music publishers case, one of the arguments that the publishers are claiming is that when consumers go in and put in a prompt such as, please write me a song about the death of Buddy Holly, Claude doesn't respond, oh, here's the lyrics to American Pie, but rather, here's a song I wrote about the death of Buddy Holly. But in actuality, what it generates or could generate is the American Pie lyrics. So the potential here for infringement based on the use of the AI is huge. Next slide, please. So the right to publicity is behind some of the fake cases, and they arise out of state laws and state statutes, although there's been a lot of movement to try to get some federal laws in place. And the law is essentially that name or likeness must be, use of a name or likeness must be approved by its owner. Next slide, please. So, and in Virginia, for example, and there's many states that have similar statutes, there are civil and criminal penalties for use of a name, portrait, or picture without having obtained the written consent of the person whose picture that is. Next slide, please. And with some of these unauthorized clone voices, the right to publicity is what's coming up. So last year, there were a couple songs that were generated using what sounded like a famous celebrity voice, Drake, and they called it fake Drake, as well as the band The Weeknd. And consumers thought it sounded exactly like them, but these songs were not written by them. They were in fact written by AI. And the recording industry condemned them as infringing content created with generative AI. Similarly, Scarlett Johansson had been asked to use her voice for an OpenAI program and did not, and she said she didn't want to do it. And then unbeknownst to her, there was some voice that sounded just like hers. So she claimed it was a personal attack, and that her voice should not have been used without her permission. And in fact, she had not given them permission. And then just a couple months ago, another couple voice actors have sued 11 Labs for the use of their voices, saying that they're using clones of their voices with same exact vocal timbre, accent, intonation, pacing, vocal mannerisms, etc. Next slide, please. So there's been some laws and some movement here, and we'll get more into this in Kevin's session on some of the regulations. And the Copyright Office in this first part of the report has suggested several federal laws on digital replicas, including the No AI Fraud Act, which would establish IP rights in voice and likeness and prevent the use of unauthorized digital voice replicas. Similarly, No Fakes Act also has a draft to recognize the right to use or to authorize the use of image, voice, or visual likeness in a digital replica. Tennessee has the Elvis Act. No cases have yet been decided under it, but went into effect in July, adding digital replicas as an existing right under their publicity laws. The California laws have also put out a bunch. The governor approved several bills that would require contracts to specify whether or not they're using AI digital replicas, as well as provide penalties for making or distributing any late performers or deceased performers' digital replica. There's also a requirement that online platforms remove or label deepfake content related to elections, although the governor recently vetoed some of those relating to elections, saying that it was imposition on some of the First Amendment and free speech rights. Next slide, please. So some suggested contract terms in light of the issues and potential legal risks with use of AI, including representations that the work has not been authored using AI. This is helpful for creative works, as well as businesses that are working with companies that are creating or generating any type of content. You want to make sure that they're not using AI, or at least not using anything that's infringing or potentially infringing based on the use of AI. Next slide, please. With that, I'll turn it over to Kevin for an exciting discussion more on the regulatory framework.
Thank you, Amy. It's certainly a lot you covered there and some really important issues. We're going to take, before we get into the talk, we're going to take our last poll question. So if you can, as you know, respond to this so that we can make sure you can get your credit. The question is, what are your biggest concerns about AI in your work? Is it protecting proprietary information? Is it hallucinations, mistakes, false information being generated? Do you have legal concerns over liability? Are you concerned about it taking over your job or your role in the company? Or do you have other concerns? So you have a minute, please, to answer those, and then we'll move on to the talk. And again, as a reminder, if you've requested CLE credit, you do need to fill these out and make sure that you submit it so that we can keep track. Okay, so we finished up, and looks like a pretty good split. Protecting your proprietary information, hallucinations, legal concerns all have roughly 34%. I guess protecting proprietary information is a little bit less, but anyways, it's a good mix of issues, and that's some of the challenges that people and organizations have in rolling out AI. So if I could have the next slide, please. So I'm going to be talking about the legal and regulatory environment that's developing around AI, and just a couple of sort of high-level issues I wanted to discuss to frame. First is, it's really interesting that lawmakers and regulators are trying to regulate AI as it's being developed. Usually, as you know, the law is reactive, not proactive. But in this case, because of the concerns around AI, we're seeing a lot of developments at all different levels of government trying to get out in front of it, but at the same time promote it. Because most government agencies, most governments around the world believe that it can be a really vital tool. And so you have this tension of laws and regulations being developed quickly, which could lead to mistakes. It could lead to unintended consequences, but also could mean, if you do it too much regulation, you could hurt your your industry and not be able to develop in a way that you want. And it's also taking place at all branches of government. So it's at the federal level, state level, even some municipalities are developing laws or regulations or ordinances around the use of AI. And so it's important to sort of keep that in mind if you're starting to use or develop AI for your own use, because you may not intuitively think about where the law will come from. Next slide. So just going to walk you through some of the different levels of legal and regulatory framework that's developing. The first that's coming directly from the White House or the executive agencies. And the most important is the executive order, the top one, that came out in October of last year. And it, I believe, is the longest executive order that was ever published. And again, that goes to, they're both trying to promote the development of AI in training and education in the government and in the United States in general, but also protect against concerns, both intellectual property concerns, privacy concerns, liability concerns, national security concerns. So it's a very extensive report that directed federal agencies across government to come up with different policies, regulations, orders of their own to decide how it's going to be implemented within their sphere of influence. About 2 or 3 months later, the OMB published some implementation guidance, which essentially told government agencies how they could procure and use AI, and I'll talk about that in a few minutes. But it is basically a tool that they should use and what considerations they need to make before they procure it. And so for those people who are doing business with government, it's a useful tool to take a look at and see what agencies are considering. And then because of all the risks associated with AI, the executive order also directed NIST to come up with a risk framework, which they published probably about 6 months ago, I believe. But all of these are not static in the sense that we continue to see on, if not a daily, a weekly basis, where government agencies are introducing policies, regulations, either under the authority of this executive order, or just through their own rulemaking process, because this is such an important issue within the government. Next slide, please. And this is just a list of some other policies or documents that have been published. I believe Amy referenced some of the work that's come out of the Copyright Office regarding training data and outputs, also around patent applications. There's the Artificial Intelligence Accountability Report that came out of NTIA. DoD, which is often exempt from the executive order in a number of areas, has developed its own guidance for its use and for contractors. And then the first one listed there is some joint guidance that came out a number of months ago that from a number of different agencies that was basically telling anyone within their jurisdiction that existing laws still apply. So if you are using AI in a way that is discriminatory from an employment standpoint or from a financing standpoint, just because you use AI doesn't mean you can avoid requiring or being subject to those laws. And this was an interagency report that came out and sort of highlighted that for those that are covered by those agencies. Next slide, please. Congress, as Amy has suggested or noted, there are a number of bills before Congress. This is just a small number of all of them listed. Again, they go everything from promoting AI to make sure that the United States is a leader, to invest money in training, in STEM, issues around making sure that we can have students come to the U.S. and study and stay. So there's that aspect of it, making sure that the CHIPS Act, which is a separate act, but promote the technology so that we have the infrastructure to support AI. I mean, there's a lot of efforts in that area, but then also laws, as Amy mentioned, around training data, around risks, privacy, discrimination. We'll talk about some of these, but just wanted to point out that Congress, while it hasn't passed any federal law in this area, is certainly discussing it. And some of that may be just for show, but some of it is, I think, because there is a high level of concern in making sure that the U.S. addresses this in a significant way, because other countries are. And I'll talk about that in a few minutes. Next slide. Just going to touch, as Amy said, there are a number of cases that are out there, not just on the intellectual property side, but there are several enforcement action and cases around privacy. Privacy is a big concern because, as you may know or likely know, this is essentially generative AI is a black box, and information goes in and input or outputs are taken, but it's not clear where that input came from, where that training data, what information is used. And there's a great deal of concern that personal information is being used and aggregated in a way that could identify or violate an individual's privacy. And in a lot of ways, the privacy community is taking a lead in looking at ways for governance and regulation of data of artificial intelligence because of those concerns. There are also antitrust concerns, liabilities for errors when you from the output and people relying on that. There's a whole other set of issues that need to arise that are being enforced outside of the legal and regulatory standpoint. Next slide, please. As Amy also said, a number of states have passed laws that would regulate various aspects of AI. Not surprisingly, California has taken a lead on this, and Amy listed a number of bills that became laws. There's rulemaking that's developing in California related to AI, and particularly around data protection. It is important to note that several states that have comprehensive data protection laws include efforts that regulate automatic decision-making in things like advertising, which broadly defined would include artificial intelligence. So some folks have looked at that as a way that these laws can be used to regulate artificial intelligence already. A number of states have developed commissions around researching the impact of AI. Again, as I said earlier, and we have on our team here a former state legislature who was in the Virginia General Assembly when the internet was first growing and being developed. And he said at that point, the General Assembly decided to sort of take off a hands-off approach because they were concerned that they didn't understand the technology and they didn't want to impact it too negatively. That approach is changing and people are trying to regulate it. And like I said, it is going to have an impact. It's just not sure how. Another interesting development at the state level is that states are, through executive orders, directing how government agencies within the state can procure AI products and services or create them themselves. So even without the authority of laws, there is that impact, for businesses that are going to work with state government agencies. Next slide, please. And then internationally, as I said, some are moving even more quickly than the United States. The EU AI Act became into law in August of this year. And I think in February of 2025 is when the first authorities or regulations kick into effect. But countries around the world and transnationally, they're looking at developing blueprints and form laws, codes of conduct. There's just a lot of work in trying to figure out what to do with AI. So if you're dealing internationally, even if we don't have a law here in the United States, I do think it's important to check to see if the region that you're dealing with does have an AI law and if you're subject to it. Next slide, please. So I just want to talk a little bit about, again, we don't have anything right now in the United States that's a comprehensive AI law at the federal level, but you can see some trends in terms of how AI is going to be regulated. First of all, I think it's important to recognize that there is some effort to look at the AI system as a whole. We're talking billions, if not trillions of data and power, our data that is being processed and used in a way to create these large language models that Amy suggested. These are significant efforts, which is why these companies are raising billions of dollars to try to generate this. This takes a lot of work and a lot of computing power, and there are a lot of societal and other implications associated with that. But generally, the bigger the AI system, the more powerful it is, and the greater concern it can have a risk, particularly on a national security standpoint. Training data is all the data that is used and put into the AI system. It's labeled, and then it's used to develop the models. And this is, well, just to explain how big this is, there are some people who worry that in the next couple of years, we won't have enough training data left because they are literally taking everything they can off the internet and using that as training. And so at a certain point, they're concerned that there won't be training data, that'll just be AI output data because we've used all the training data. This is a significant amount of data. The issues that Amy discussed around intellectual property, copyright is certainly a big issue. I mentioned privacy, but there's also issues around completeness. There's issues around fairness and discrimination, because if you don't have the data and use it in a way in which it's current or accurate or complete, are you going to be able to generate reports that don't discriminate or outputs that don't discriminate? Are you going to build models that are somehow biased in some way? Because what you do is you take these large training data, but then you develop these particular applications on top of them where you narrow down the aspect of training with your own data sets. And that's where some of this discrimination can take place. You have the models. One of the things that regulators are looking at is they want you to describe, be transparent on how these models were developed, what training data you used, how they've been tested, how you've made sure, how you can confirm that it's fair or adequate, complies with applicable law, and then the same thing on the outputs. So there's a number of different layers that take place, and it's a very complex system, both from a governance standpoint and an implementation standpoint, but as you can imagine, from a legal standpoint, trying to draft laws around this, and then all the different constituencies pushing back as to what's considered a big enough training system to cause concerns. Next slide, please. Many of the approaches are risk management approach, so they're trying to identify those systems that have the greatest risk, whether they be because of the size or because of the applications that they're being used for. So a lot of the framework that you're seeing developed is focusing on an assessment before you deploy it to make sure you understand what the risks are, whether they be legal risks, ethical risks, national security risks, and how you can mitigate those. Also, once you deploy a system, there's, in a lot of ways, and I'll talk about this, an effort to continue to monitor those systems. You can't just put it out in the world and assume that it's going to be fine. You have to continue to monitor how it's working, see if there's any emergent behaviors, and making sure that if there are, you have a way to keep track of them and to deal with any unintended consequences. In addition, there are regulations. It appears we're moving towards domain-specific standards. So if you're in a highly regulated industry, maybe if you're in the critical infrastructure, if you're in finance, if you're in other areas, certainly the legal community, understanding how AI is going to generate output in those domain-specific areas, and whether you can be compliant with laws, whether you can be compliant with your ethical obligations. There's a whole level of risks associated with this that people are needing to think through and deal with. Next slide, please. We're running short on time, so I won't go into a whole lot of detail on this. I just wanted to point out, as in anything that we do as lawyers, definitions are really important. I will say that defining artificial intelligence system from a legal standpoint is proving to be very complex because it is such a difficult and technical solution, technical definition. And so for lawyers trying to understand it, for lawmakers trying to draft it, and then for folks who are in the industry trying to push back and define where the red line should be drawn, it's really important it's proving to be a real challenge. We're getting into areas about whether a system is a high impact or a critical impact, if it's safety impacting, if it's making consequential decisions. All these are defined terms, but obviously they're very vague, and it's going to be important to understand, one, if and how they apply, and then what the consequences of that are going to be. Even the definition of what a model is, whether it be a foundation model, a frontier model, which is essentially a foundation model, but that's so cutting edge that it's considered to be out in the frontier, and the risks associated with frontier models are often assumed to be greater than foundation models. And then open models are models where the developers are making how they develop the model open, which in some ways some people consider to be safer than traditional proprietary models, but in other ways people consider to be riskier because it's easier for people who don't have training to build bad act models, if you will. So there's still a lot of uncertainty. And again, the point being that nevertheless, we're moving forward in an area where people are trying to regulate it on a daily basis. Next slide, please. So how can an organization deal with this complex area? I think one way is to understand that AI is going to cut across all through your organization, and it's going to have a number of different risks, and it's going to require the input of a number of different stakeholders. It can't be just the technology folks. It can't just be the legal department. It can't be the regulatory compliance department. To identify the potential risks, understand what's ethical, what's fair, to understand intellectual property rights associated with what the input and the output, to figure out how you're going to train these models and then test them is going to require full team of folks working together. And that has been the case in a certain, technologies over the past 10 or 20 years. But I do think, and from what people are saying, it's clearly going to be a greater need for that, because no one department or person is going to be able to answer all these questions. Next slide, please. One of the interesting things, and I've mentioned this a couple times, is we're seeing terms like fairness, equity, ethics be integrated into laws and regulations. And again, that's because of the concerns associated with models being developed that maybe haven't been fine-tuned with the right data to come out with output that is fair, or somehow non-discriminatory. And I'm sure some of you have seen over the years studies that have been done about facial recognition software coming up with unfair results, law enforcement use of AI coming up with discriminatory results. I mean, there's been a number of studies that have shown that the training data, if not properly used and labeled and then included into the models, can create unfair results. And so there's this push to make sure that the law and regulations address those issues. The challenge is trying to define that and then understanding what that means. For instance, how much training data do you need, and how well do you have to label it and test it to make sure that it's fair and ethical in a way that many people can't even understand how the result is being done, is a real challenge. And it's going to be interesting to see how regulators and courts apply that as these systems become deployed. Next slide, please. So just to give you sort of a high-level overview, this bill here is in Congress right now. I think that there's going to be as I said, there's going to be an effort through legal and regulatory efforts, but also through your customer contracts. They're going to be the ones that are going to push back on what you're doing and making sure that they're protected. And I apologize, I said this was a government bill. That's the next slide. This came out from the OMB release that I mentioned earlier about what federal agencies can do when they're building or procuring AI systems. And they have sort of distinguished between safety impacting purposes or use of AI. So that might include issues around first responders or autonomous vehicles or transporting hazardous chemicals. There are duties associated with safety impacting AI use. Next slide, please. And then rights impacting AI use. And that goes more towards, as the name implies, decisions that could impact an individual's legal, personal, civil rights. And depending on what your system does, it could do both or it could do one. And so an agency has responsibilities, if it falls into either category, to take certain steps before it starts to use it. Next slide, please. So by December 1 of this year, before they can use new or existing safety or rights impacting AI, they must complete an assessment, they must test for performance in the real world, and they must independently evaluate the AI. Now, I say December 1st, there's a way for government agencies to ask for this to be delayed. I expect many of them will, but the goal is to try to, as quickly as possible, implement this. And then, as I said, it's not just testing initially, but an ongoing basis to continue to do monitoring, evaluate the risk, mitigate risks as you find out as they evolve. There's always this concept of a human in the loop to make sure that humans understand what's happening and be the final check in terms of some of these rights impacting and safety impacting systems, to make sure that you're not just totally relying on the system itself. And then I mentioned transparency, to make sure that there's plain language, notice, and documentation, so that citizens can know if AI system is being used in a way that impacts them. Next slide, please. In addition, if it's rights impacting, there are additional obligations that are imposed on agencies, both before they start to use it and then on an ongoing basis. And again, the feeling is it is so critical that citizens know how these systems are being used, and they know that it can be used in a way that's equitable and fair. And there's a way for them to have a feedback if they're concerned about that. Next slide, please. This is the bill that I mentioned in Congress. This has uses different words: high impact AI systems, critical impact AI systems. High impact AI systems are the ones that would deal with sort of more of the rights-based things that we talked about before. Critical impact AI systems would deal more with the safety issues around critical infrastructure. In both of these instances, I mentioned the Department of Defense and intelligence communities are excluded. But if you're developing a system in this area, if you're selling it to another government agency, you would be required to be subject to this if this were to become law. And then there are general reporting requirements as well. I guess I should say, it's not to be misleading. This would apply regardless, not just to a government agency, but if it was used in the private sector as well, if that were to happen. Next slide, please. And then to the point that Amy made earlier, even without a law, I think it's important for lawyers to understand that there are legal considerations around AI right now. For instance, government agencies are making it clear that you can't use AI to avoid the law. So if you've got a regulation that you need to comply with, or that be non-discriminatory employment hiring, you can't use an AI system and then say, well, that's not our fault. They're the ones that came up with a problem. And there's a court case right now looking at that. I believe it's in California. Contractual considerations, I think, are critical right now in making sure that you understand not just what your existing contract language has around issues around IP, liability, compliance with laws, but also going back and reviewing your previous agreements to make sure if you have vendors that have your data, whether there's any protection in there. And if you feel like you need to have protection either from a business standpoint or whether from a regulatory standpoint, you need to go back and see if you can change the terms or at least find out how they're using it. As an example, some of you who use LinkedIn may have seen that LinkedIn recently changed their privacy settings so that your data was automatically being used for training of AI data, unless you excluded your information from that, unless you went into the system and firmly checked no. Those are the type of things that are happening now because a number of businesses, even if they weren't in the data or AI business, are now seeing an opportunity to do so. And so we're seeing a lot of effort for people to start using the data that they're collecting in ways that maybe you didn't contemplate them having when you first started doing business with them. Next slide, please. And then just some key takeaways. Like I said, consider the guidance coming out of the executive branch. Consider state laws and policies as well. Multi-stakeholder team to identify and mitigate the potential risks of AI within your organization. Consider risk of using generative AI programs that have relied upon copyrighted clones or cloned works or cloned voices to train its models or create works. And then consider changing contracts and reviewing your existing agreements. And Biden, I think we came in at exactly at 3:10.
Great. Well, thank you so much.